You have the floor, Dr. Turkut.
I'm just going to, okay, this is working. Dear President, dear members of the Tribunal, and distinguished members of the audience, it's an utmost pleasure for me to be here today and take part in this important initiative. And as one of the rapporteurs of the Tribunal, I will share with you some of the findings of the Impunity report, which I had the pleasure to co-author with Professor Yves Ag from Ghent University. My name is Emre Turkut, and I work as a postdoctoral researcher at Hurt School Center for Fundamental Rights. Now, before delving further into the report, I want to share with you an outline of my presentation. I will first briefly introduce the report by mentioning what sort of a definition we used for impunity in the report, and what our main research question is, what sort of a methodology we have employed, and what sort of sources we have used in drafting the report. I will then try to show you that impunity is a long-standing problem in Turkey and cannot be limited to the aftermath of 2016 attempted coup by looking specifically at two important periods in the history of Turkey, and these are the periods after the military coup in 2018 and the period after Kurdish problems started in the late 1980s and in the 1990s. And finally, I will delve further into the question of how impunity functions in the Turkish domestic fora, and look at 5 main root causes of impunity, as you see here, but I will speak further on these factors or root causes. Now, as a whole, in the report, we deal with one main research question, and so the question is there an effective system of preventing and monitoring torture or mistreatment for people held in detention? If yes, how does it function in reality? And if not, can we speak of an organized impunity in Turkey? Now, I will try to dissect and analyze the components of these questions in the subsequent slides. Now, starting with the definition of impunity, right? So what sort of a problem that we talk here today? Now, in the context of international law, we define impunity as the failure or the impossibility of bringing the perpetrators of serious human rights violations to account and justice. This is from the UN guidelines, and we clearly adopted the same definition in the report. And when we say perpetrators, in an impunity context, we refer to those responsible for acts and omissions amounting to serious human rights violations. But in this very specific context, the focus is usually on state agents or officials, for example, law enforcement agencies and security forces, police and military members. Now, and these human rights violations are some of the gravest violations of internationally protected rights, such as torture and extrajudicial killings. Now, besides constituting a denial of many human rights, particularly the victim's right to redress and justice, impunity also violates state obligations under international law, both negative and positive obligations, because it's a direct threat to the rule of law and human rights, which clearly states have both respect and promote under international law. So where do these state obligations come from? Where do these emanate from, right? So states sign and ratify international treaties to undertake these obligations. Turkey, for example, has extensive obligations under the European Convention of Human Rights, under the International Covenant on Civil Political Rights, as being signatory to both treaties. For example, in the context of right to life, under Article 2 of the European Convention, under Article 3 of the European Convention regarding the prohibition of torture and ill treatment. And, of course, the right to effective remedy under Article 13 of the Convention. Now, Turkey has somewhat more specific obligations under the UN and European Conventions on torture, such as the obligations to take effective legislative, administrative, judicial or other measures to prevent acts of torture and provide redress for victims under different articles of these two torture conventions. Turkey has also incorporated these obligations into its domestic legal framework. For example, Article 17 of the Turkish Constitution clearly prohibits the use of torture. And Article 49 and 95 of the Turkish Penal Code, for example, clearly prohibits and unequivocally prohibits the use of torture by police. Now, in terms of our scope of inquiry, as you see here, we try to address whether the Turkish state complies with its negative and positive obligations for crimes of torture and ill treatment, as well as extrajudicial killings, which are allegedly committed by the Turkish state officials, or if there is an impunity with regard to these crimes. Now, perhaps one final methodological point. In the report, we distinguish between structural impunity and functional impunity, structural or normative impunity, or functional or factual impunity. Structural impunity is the impunity that derives from or takes its root causes in the legislation. For example, the lack of appropriate legal mechanisms to address impunity could be a great example for it. Functional impunity is the impunity that derived from the practice. For example, the lack of political will to hold state officials accountable. So in the report, we address both structural impunity and factual impunity in Turkey. Now, the time frame of the report. Now, we devoted an entire whole section to the legacy of impunity in Turkey. But in terms of our case study selection and the report's temporal focus, we decided to zoom in on more recent years, especially after the 2016 attempted coup. This is mainly due to the fact that the practice of impunity, as well as the allegations of torture and ill treatment, have dramatically increased since 2016. And in the report, we zoom in on three case studies. These are the torture and extrajudicial killing of Gökhan Açıkkollu, the torture of several Kurdish people or individuals in Urfa, and the torture of purge diplomats in Ankara. And throughout my presentation, I'll try to mention some specificities of these case studies. Now, the legacy of impunity in Turkey. Now, in the report, we tried, as I said, we tried to take a look at two important periods of impunity in Turkey to basically show and argue that the impunity is an entrenched, a long-standing problem in Turkey. Now, to refresh our memories, Turkey experienced a military coup in 1980. And in its aftermath, immediate aftermath, the coup plotters took control of the state institutions and ruled the country under martial law for 3 years until 1983. And this was really a repressive, oppressive, and to a certain extent odious regime, which led to devastating, horrible consequences for human rights. Just to give a few examples, more than 500,000 people were arbitrarily detained on political grounds, and hundreds of thousands of people were subjected to torture and mistreatment. And in 1982, the military rule imposed a constitution on the country, which is the current constitution of Turkey, but they gave precedence to their interests over individual liberties. For example, a provisional article in that constitution provided full immunity to the leaders of the military coup as well as military state officials from any form of prosecution. Now, if you remember the 2010 referendum, this provisional article of the Constitution was revoked. And criminal cases were initiated against the coup plotters, including the famous figures Kenan Evren and Tahsin Şahinkaya in 2012. And they were later convicted for crimes against state, but both died during the appeal procedure, so no one was held accountable for these massive, massive crimes. Now, another important period in the Turkish history is the PKK conflict in the late 1980s and 1990s. Now, during that period, Turkish state and PKK engaged in violent confrontations. In response to address this unrest, Turkey declared a territorial state of emergency. And importantly, the subsequent resulting emergency decrees created the office of regional governors. These regional governors were responsible for taking any and all measures in the furtherance of emergency decrees and in the furtherance of state of emergency. And they used coercive exceptional powers. For example, they could impose curfews. They could prohibit anyone from entering any emergency region. They could evacuate villages. They could disband the media outlets, so on and so forth. So, of course, this resulted in some of the most flagrant human rights violations against the Kurdish people, including systematic torture, kidnapping, enforced disappearances, extrajudicial killings, forced evacuation of villages, and similar massive human rights infringements of large scale. Now, these teams have consistently recurred in a series of decisions by the European Court of Human Rights, and in many cases, the European Court of Human Rights condemned Turkey of violating many human rights under the European Convention on Human Rights. Now, to give some credit to the Turkey's current government, especially after these ECHR cases in early 2000s, Turkey took some positive steps, right, to address these massive violations as well as the resulting impunity from them. Turkey, for example, adopted a well-known compensation law in 2004, which provided with the victims, provided victims with the possibility to apply for a compensation for their losses. This legislation applied retroactively and were applicable for the events between 1987 till 2004. And victims could apply for compensation on the grounds of state liability for these human rights violations. And other steps that Turkey took, the Turkish government took, were largely owing to the European Union negotiations. Turkey back then in early 2000s were seriously pushing a membership to the EU, and to meet the certain criteria like Copenhagen criteria, Turkish government adopted a very, very ambitious program of legal reforms. For example, Turkey adopted a brand new penal code and code of criminal procedure in 2005, definitely with greater safeguards in the field of pre-trial detention, because it reduced the detention period, so on and so forth. But as we argue in the report, these positive steps served nothing more than a band-aid on prevailing impunity problems. And somewhat unsurprisingly, the practice of impunity as well as the allegations of torture and ill treatment emerged as one of the most common themes of Turkey's human rights records since 2016. Now, again, to refresh our memories, on that night, Turkey, an attempted coup took place in Turkey, and that plunged the country to a national state of emergency. And Turkey, in its aftermath, derogated from a wide range of rights under the European Convention and International Covenant on Civil and Political Rights. Of course, the precise details of this attempted coup, like who really organized the attempted coup, is still murky, is still shady. But the Turkish government still maintains that this attempted coup was instigated, perpetrated, organized by a faction within the Turkish army allegedly affiliated with the Gülen movement, which Turkish government still sees as a terrorist organization. Now, the national state of emergency stayed in effect for 2 years. And during this 2-year period, Turkey adopted 32 emergency decrees with atypical, as we argue, atypical emergency measures. These emergency measures, consisted of collective dismissals, mass arrests and detentions, and broad institutional closures. These measures were atypical for a number of reasons, because these emergency measures are quite unprecedented, even for a country like Turkey, because Turkey has extensive emergency background and experience. But these emergency decrees were quite unprecedented and new. Now, importantly, Turkish emergency decrees imposed very drastic procedural and substantive restrictions in the field of pretrial detention and on the rights of defense. For example, one of the very first emergency decrees in July 2016 authorized detention without access to a judge for 30 days. Of course, for 30 days, 30. So this, of course, goes the other limit that is set by the European Court of Human Rights. But the asserted reason for that was the Turkish state authorities had difficulty of collecting evidence because of high number of suspects. So Turkish government wanted to arrest and detain people first, and then they decided to collect evidence. Now, this provision stayed in force only for 6 months, when another decree in early 2017 reduced it to 7 days. But in this 6-month period, a very, very large number of criminal proceedings had already been conducted. And in terms of defense rights, some emergency decrees authorized a 5-day initial period of incommunicado detention. That means that suspects could not see or are prevented from seeing their lawyers. Lawyers have also been prevented from hearing all the evidence. Defendants also have been prevented from hearing all the evidence against them, and lawyers have been prevented to accessing the contents of a file. And also relevant is that family visits and phone calls had also been strictly limited, and these changes cumulatively in the 2016 attempted coup aftermath made the people in detention more vulnerable to abuse, and including torture and ill treatment. And again, unsurprisingly, from the very first days of the 2016 attempted coup, very, very disturbing images have been extensively covered by national, international media outlets, as well as international organizations and NGOs. Now, just to slow down, I wanted to attach a coverage by the Anadolu Agency, which is a state-run media news company. So this is a picture that I took from their piece on 18 July 2016, 3 days after the attempted coup. And the gentlemen you see here are, alleged coup plotters. So they were taken in custody, and only after 2 days, they were, if you can see their faces, right? So they are covered in bruises and some. I definitely see blood. So these and similar cases have been extensively, as I said, covered by media, international organizations, and NGOs, right? So we devoted an entire section to these international reactions. So I don't want to repeat who said what, but what I can briefly say that these international reactions have two common ground. One is the rising allegations of torture and ill treatment in custody, in Turkey's post-coup period, and the increasing failure of the Turkish government to respond to these allegations. So I provided a couple of slides here on the report of the UN Special Rapporteur on torture. And he writes in his report that he heard persistent reports of widespread torture, including severe beatings, electrical shocks, extended blindfolding, handcuffing, sleep deprivation. Similarly, the UN High Commissioner for Human Rights rightly claims that or finds that the perpetrators included members of the police, gendarmerie, military force, and security forces. Maybe I should just briefly mention that one of the most common threats in the stakeholders' submissions that they submitted for the Universal Periodic Review was the escalation of torture and violence against detainees, while at the same time security personnel may have committed crimes on behalf of the government, enjoyed immunity from prosecution, both during and after the attempted coup. And these are also the recurring and common themes in the reports of the UN Committee Against Torture. Right. So now the root causes of impunity, right? I mean, how does the impunity, both structural and functional impunity, functions in Turkey's domestic fora? Now, in the report, we comprehensively identify 5 factors that cumulatively ensure and reinforce the patterns of impunity in Turkey. And one such factor or root cause is the gaps in the Turkish legal structure. Now, Turkish domestic law has many impunity clauses and many authorization requirements. So just to briefly mention that Article 120 of the Turkish Constitution, as a rule, provides that an authorization by the highest ranking administrative authority is required to prosecute the public officials. Now, for crimes of torture, such authorization is not required, and public prosecutor shall immediately investigate as soon as he or she is informed of these charges through report of a crime or through any other means. But then the established administrative practice clearly shows that the administration tried to hinder these investigations by subjecting them to an administrative authorization. They basically claim that, and it's a consistent practice by the administration in Turkey, that they say that this investigation cannot go on without our authorization, which basically delays many investigations. Just to give one example, as most of you would remember, Hrant Dink, who was a Turkish Armenian journalist, and he was murdered in 2017, right? So in his case, there were clear indications that the gendarmerie officers of Trabzon and Istanbul had been involved in his murder or extrajudicial killings through at least negligence, and this has been corroborated by many investigation reports and as well as the finding of the European Court of Human Rights in 2010. However, formal investigations into these officers had been considerably delayed because the administrative bodies decided to not grant the administrative authorities for a long time, and 14 years on, impunity still lingers in his case. 2 impunity clauses that I can mention, for example, the MIT personnel, the Turkey's intelligence service personnel, enjoy personal impunity unless the head of intelligence agency issues an authorization for them, for public prosecutor to prosecute them. And also an authorization by the president himself is required to put the chief of general staff on trial, and we know that such authorizations will not come, so there is an effective impunity with regard to or arising from the gaps in the Turkish legal structure. Now, there are also some special laws, like lex specialis. I don't know if it's the right term to put it, but in 2016, the Turkish government adopted a legislation which gave a de facto impunity to state security forces for the alleged crimes took place in 2015 and 2016. So if you remember that period in the aftermath of the July 2015 elections, Turkey adopted an anti-terrorism policy which was very reminiscent of the 1990s. So they the Turkish government and the anti-terrorism operations killed many Kurdish civilians and basically destructed the towns to the ground. Now, there was massive, or there were credible reports of massive human rights violations, but the Turkish government adopted this very specific, very special legislation. Now, to try these perpetrators, an authorization by the by the ministers is required. But I haven't seen any investigation in that regard so far. And a number of emergency decrees adopted in the aftermath of 2016 attempted coup also, kind of brought further complication to this field. 2 emergency decrees adopted impunity clauses to state officials, to both state officials and civilians who took steps or measures to suppress the attempted coup, right? So we extensively deal with it in the report. But the point is, this has blocked the ways for accountability for many massive human rights violations, for accountability in the 2016 coup period. Now, important thing is that the Turkish main opposition party, CHP, took these 2 impunity clauses to the Turkish Constitutional Court, but Turkish Constitutional Court rejected to rule on this, on the unconstitutionality of these impunity clauses, because I quote, they ruled that they aim at protecting state agents in fulfilling their legally mandated duties in the fight against a terrorist organization, referring to the Gülen movement, FETÖ, which poses a grave threat to survival and security of the nation through its clandestine infiltration to state mechanisms. So this was the reasoning of the court when they rejected to rule on the constitutionality of these impunity clauses. Now, the second factor we identified is the political rhetoric, both downplaying the scope of the impunity problem in Turkey, as well as reinforcing patterns of impunity. So what's really important here that I want to draw your attention to is the sheer contrast of Turkey's positions in official occasions and unofficial occasions. Because in official occasions, Turkish state authorities basically avowed their commitment to zero tolerance for torture and label the allegations of torture and ill treatment as a misinformation campaign against Turkey. But in unofficial occasions like TV interviews or rallies, the authorities have seemingly encouraged the use of torture for certain people, for certain groups like Gülen movement and the Kurdish people. Or at least they provided a moral legitimization toward this. So I'm just going to quote President Erdogan in one of his rallies in 2017, and he said, I quote, "We are purging every Gülenist in our state institutions, and we will eradicate this cancer from the body of this country and the state. They will not enjoy the right to life. Our fight against them will continue until the end. We won't leave them wounded." I mean, this is basically cruel and such cruel political rhetoric results in reinforcing the patterns of impunity in the country and contributes to the climate of impunity. Now, the third factor that we have identified is the lack of political will to hold state officials accountable. And in the report, one of the 3 case studies that we took a particular look at is the torture of purge diplomats in 2019. Now, a report by Ankara Bar Association, which is an association very critical of the government, very critical of Turkish government's authoritarian policies, as well as many other reports by different human rights institutions in Turkey, provided clear evidence of torture of these individuals, including stripping people naked, beatings, threats of being raped with batons. But Turkish authorities did not take any step, any meaningful step to address and prosecute these violations. And in August 2020, Ankara Chief Public Prosecutor Office issued a non-prosecution decision into these complaints, into these very big, very credible complaints. And that only shows the lack of political will to hold state officials accountable. Now, the fourth factor is the ineffective and delayed investigations by prosecutors. Now, in the report, we gathered the judicial statistics on Article 94 of the Turkish Criminal Code, on Article 95 of Turkish Criminal Code, on severe torture. 94 deals with like basically regular torture, and 95 deals with addresses consequential severe torture, which leaves, for example, a permanent mark. So then the sentence of 3 to 12 years is increased by 1/2. So these are the statistics of the judicial statistics between 2012 and 2018, right? So every year, so the laser is not working, sorry. So each year, if you take a look at the numbers, there have been over 1,000 criminal complaints. For example, in 2013, it's above 1,700, 1,600, 1,400, above 1,000 criminal complaints. And over 90% of them are not investigated at all. So out of the 10% that finally reaches the trial stage, only a handful of imprisonment decisions is issued. So the ratio stands around 1%, perhaps less than 1%. So there is clear unwillingness on the part of Turkish prosecutors to investigate these serious claims of torture and eventually hold perpetrators to account. And maybe the second case study that we zoomed in on in our report is the torture of Kurdish people in Urfa in 2019. Now, in May 2019, there had been a clash between Turkish security forces and the PKK, and one police officer lost his life. And to address this, basically, the Urfa, which is a province in the Turkish southeastern region, Urfa Public Prosecutor Office opened up an investigation, and they detained over 50 people. So during the custody, several detainees reported that they had been subjected to torture and ill treatment, including rear handcuffing, blindfolding, hooding, electric shocks, beatings, sexual abuse, and verbal threats. But in a very brief statement, the public prosecutor simply, denied these allegations and did not open up a criminal investigation against, or did not file or public charges against these allegations. Now, the final factor that we have identified is the, to say the least, complicit judiciary in Turkey. Now, over the past decade, Turkish judiciary has been experiencing some severe challenges like harsh political pressure, arbitrary dismissals, forced transfers, and widespread censorship, both self-censorship or censorship by the government. And this has largely resulted in the politicization of the judicial branch in Turkey. Now, the judiciary should act as a remedy against human rights abuses, but unfortunately, the opposite is happening in Turkey. Judiciary itself is responsible for a series of abuses. For example, the case of Kemal Korkut, whose brother Ercan Korkut will testify later today, clearly provides a striking example here. And for those of you who don't know, Kemal Korkut was a university student who was killed by Turkish police officers during the Newroz celebrations in 2017. And the clear and conclusive evidence was presented before the court, including the footage of the incident, basically clearly showing that how and by who he was shot. But a Turkish court decided to acquit his murderer, the Turkish police officers, in November last year. So I will conclude by briefly mentioning some of our main findings, right? So responding to our main research question, we argue that there is no effective preventive or sanctioning mechanism towards acts of torture and ill treatment in Turkey because the legal safeguards are insufficient, often not respected. The Turkish authorities show no willingness to prosecute these allegations and hold perpetrators accountable. There is a widespread judicial practice of not prosecuting the public officials. And add to that, perhaps more importantly, the independence of the Turkish judiciary cannot be trusted anymore. So the findings of our report clearly show the organized, institutionalized, and entrenched impunity problem in Turkey. And we regrettably came to the conclusion that the practice of impunity has virtually become the norm for serious human rights violations committed by state officials. Now, with that said, I'm concluding my presentation, and thank you for your attention. Looking forward to the questions.
Thank you very much, Dr. Emre Turkut, and thank you very much also to Professor Haag, because you are co-author of this extensive report, so thank you both of you. And now I will turn to my colleague, judges, in order to clarify some points and to put you some questions. Judge Maliverni, could you start?
Yes, thank you, Madam, and many thanks to you for your excellent, to both of you for your excellent and very comprehensive report, and also for your very clear presentation. I would like to ask you 3 questions. The first one relates to the 5 factors that you mentioned and that could explain the phenomenon of impunity in Turkey. Mm-hmm. You rightly say that they are closely linked, and one may be the cause or the result of the other. But still, in your view, do you think that one of these 5 explanations is more important than the 4 others? So this would be my first question. And my second question relates to the comparison between the situation of impunity after the 1980 coup and now. Do you think that the situation now is worse than the situation after the 1980 coup, or is it almost the same? And then the last question relates to what you call the structural impunity in Turkey. And these laws which prohibit, which say that the police cannot be prosecuted without the permission of the relevant administrative authorities. And what has struck me is also the judgment of the Constitutional Court of Turkey. You read the main wordings of the judgment, which says that the state agents, these provisions aim to protect state agents in fulfilling their duties, which is, of course, unacceptable. And my question is the following. Had the European Court on Human Rights had the opportunity of giving his opinion on this legislation and on the judgment of the Constitutional Court, Turkish Constitutional Court? Many thanks.
Thank you. Okay. Thank you for these excellent questions. Starting with the third question. You ask whether the ECHR has taken any opportunity to address this legislation. Not so far. So when it comes to massive human rights violations in Turkey in the 2016 attempted coup period, there have been credible criticisms that the ECHR is taken a kind of turned a blind eye to these human rights violations in Turkey, and they have been very conservative in terms of their application of the rule of non-exhaustion of domestic remedies. So after 5 years after the attempted coup, only a handful of decisions were adopted by the ECHR. And in regard to this specific legislation, specific impunity clauses, the ECHR doesn't have any cases, any upcoming cases address or concerning these impunity clauses.
On this issue, it was the Constitutional Court who
the
gave the
Turkish-
judgment. So there had been exhaustion of domestic remedies.
So, I mean, the Turkish Constitutional Court has two mandates, right? One is individual applications, so individuals can go can apply to the Turkish Constitutional Court in regard to their alleged human rights violations, both covered by the Turkish Constitution and European Convention on Human Rights. So that is the constitutional complaint mechanism. And the other mandate is that Turkish Constitutional Court can rule on the constitutionality of this of legislation, right? After this emergency legislation passed through the Turkish parliament, basically approved by the parliament, they become part of the ordinary legal framework. They become legislation, right? So that is what the Turkish Constitution says and stipulates. Now, after that, the main opposition party took this legislation to the Constitutional Court, and they basically refused to rule on whether they violate the constitutional provisions of Turkey. And that is the end of the story, as long as, as far as the unconstitutionality of legislation is concerned, from a Turkish domestic perspective. Now, the first question, 5 factors, and you ask which one is important. 5 factors, okay, these are some systematic and structural factors, right? They both arise from the legislative gaps, or also they might also arise from this culture, right? Because societal culture is really important for this kind of abuse, for impunity. So which ones are important is gaps or the impunity clauses under Turkish law is quite important, because unless you have a clear domestic legal framework, you cannot address the impunity problem. So this is, I think, the most important factor that contributes to the patterns of impunity in Turkey. And also, I would say the lack of political will, right? If a government, has, let's say, a clear domestic framework, no impunity clauses, no authorization requirements for prosecution, so on and so forth. So if a government, a political body, really believes itself that they would address this impunity problem, they can. So the political will factor is also quite important here. And I would say that that is the second most important factor of Turkey's systematic structural impunity. Now, you also ask whether the situation in 1980s were worse than the current situation in Turkey. Now, I mean, I'm not a big fan of these kind of comparisons because the applicable framework back then was different because there was a military rule, right? So the coup plotters were all part of military members. They took control of state institutions, and they ruled the country by military rule. So there was no democracy, basically. There was no rule of law. And as I said during my presentation, there were like horrible consequences for human rights. People, have been detained without any charge. They were killed. They were, there were many there were over 200 extrajudicial killings in that period. But as far as the applicable legal framework after 2016 concerned, we had a civil state of emergency. So there are also, that means that there are available channels for accountability. For example, let's say for acts of torture or for one allegation of torture, there is no statute of limitation in Turkey. Just because an act of torture took place during a state of emergency doesn't mean that the perpetrators will not be held accountable. There is no statute of limitation. Maybe in 10 years, and even in fact yesterday, I was just checking the recent cases of the Turkish Constitutional Court. The Turkish Constitutional Court adopted a very important decision in the individual application of a teacher the public prosecutor in his case issued a non-prosecution decision, but individuals can take these non-prosecution decisions to the Constitutional Court in the form of individual application. So that is what applicant did, and the Turkish Constitutional Court found a violation, and they basically stated that there is no statute of limitation in Turkey for acts of torture. Perpetrators will eventually be held accountable, and you cannot torture someone just because there was a state of emergency in Turkey, right? It was an extensive, but I'm not a big fan of comparisons. That is what I could say. Thank you.
Thank you very much. Yes, Judge Bianco.
Thank you, Madam President. In the same topic related to the emergency decrees 668 and 696,
Okay.
after the coup and to this Constitutional Court proceedings that my colleague Judge Malinberni asked. In the report you say that the Constitutional Court ruled that their aim was of protecting state agents, whereas today you said twice, also during the presentation, also in reply to Judge Malinberni's question, refused to rule. Now, legally speaking, this is not the same thing, and my question is, because this might be important for the future of the proceedings, did the Constitutional Court enter into the merits of the case? And I suspect this is the case because I see footnote 102, there are paragraphs 130, 137. I suspect that a decision with 130 paragraphs is just inadmissibility decision. So I think it's on merits. But could you clarify this, and could you say whether there was a proportionality analysis of the decrees with the Constitution of Turkey, with the European Convention of Human Rights criteria? And then we'll see, because the decision is of July 2019. It's quite early for the European Court of Human Rights to have had the possibility to take a position on this. But this is my first question. And if possible, is there any English translation of this decision? This might be very important for us to have a look. And my second question, if I can, Madam President, in your presentation you said that one of the root causes of impunity is the situation in southeast Turkey and the fight against Kurdish people. Do you kind of suggest that there is a kind of ethnic background behind this impunity policy towards state authorities, special forces, and etc.? Or this came out of like a practice and then is well established thereafter? Thank you.
Okay. Thank you so much for these, again, two excellent questions. Starting with the second one. Fight against the Kurdish people and PKK. Now, what's important here is that there is a more potential for abuse or for impunity if the situation is concerns the anti-terrorism law or legislation of Turkey. Now, since 1990s, Turkey, in 1991, Turkey adopted an anti-terrorism operations predominantly to address the Kurdish unrest, right? Kurdish people's separatist inclinations have been the main concerns for Turkish state from the late 1990s. So there is definitely an discrimination, or there is definitely certain prejudice towards Kurdish people in Turkey, because, as I said, basically the Turkish government claims that the PKK is still, going after, separating from the country, and the operation of anti-terrorism legislation in Turkey mostly concern them, mostly target them. There is definitely a certain, again, prejudice towards Kurdish people. So there is an anti-discrimination point to that kind of puzzle. Regarding the Turkish Constitutional Court decision on these impunity clauses, it was an admissibility decision, so I was kind of mistaken by the fact that, the main opposition party took these cases after they were adopted as emergency decrees, not after they were approved by the government. Now, in principle, the Turkish Constitution prohibits the Turkish Constitutional Court to check on the unconstitutionality of emergency decrees. So it was basically a decision of admissibility. And the Turkish Constitutional Court, the website of the Turkish Constitutional Court provides a summary of some of the decisions in English. And I could, be happy to help you with the summary of that judgment.
Okay, thank you very much. Judge Patsy, you have the floor to put your question.
Thank you very much, Madam President, and thank you, Professor, for a superb report and presentation, I must say. A very small question, but I was wondering whether in the course of your research, whether you ever came across any kind of reference or role that might have been played by the optional protocol to the Convention Against Torture, on the protocol on prevention.
Okay, thank you.
Thank you,
So,
yes.
okay, as you said, national prevention mechanism under optional protocol to UN Convention on Torture. As you know, Article 3 basically requires states to adopt a national prevention mechanism, but right now there is no national prevention mechanism in Turkey, which I think we failed to address this in the report, which basically shows that there is no political will to, on this. Okay, I'm sorry, it has been addressed by during the presentation. So there is no national prevention mechanism inapplicable in line with the Article 3 of the OPCAT in Turkey. Yeah.
Okay, thank you.
Thank you. Thank you very much. Yes, that's fine. Thank you.
You have the floor.
Yes, thank you for the report. One very small comment and two short questions. The comment is the following. When you started with your outline, you referred to the Kurdish problem of 1990. Now, I think I know what you meant, and I hope I'm correct, but I hope you don't mean like the existence of the Kurdish is a problem, because this is the way that this kind of terminology has been used in many places in the world. In some African states, they talk about the Indian problem. In old South Africa, they talked about the problem of black people, which were 80% of the population. And yesterday we heard from a witness of Kurdish journalists who mentioned that the Gulen, who are now victims, previously victimized the Kurds, whether that it is not for us to explain or to make a ruling on that of any kind, but I think one must be careful with terminology, and I understand that English is the first language of almost nobody here, including you as well. But that is just a small comment. But as on the point that we have to be careful with terminology, as pointed out by my colleague on the right, what exactly is the question and the answer? For example, where you summarize in the executive summary on the report on page 281, you don't have to go there, it's easy. You ask, is there an internal system of preventing and monitoring torture or mistreatment? And in the second part of the question, is there organized impunity? And then the conclusion mentions serious human rights violations. And then it goes on about adequate, effective, etc. Am I correct? I would like to spare you a long answer. So am I correct that I understand you to say that international law requires the effective enforcement of measures against serious human rights violations, but this report focuses more specifically on torture as an example of a serious human rights violation? But then from that, of course, follows, can one then say, because torture is not, there is impunity regarding torture, can one then say there is therefore impunity regarding serious human rights violations? Perhaps you want to respond. My second question is very short.
Okay. Thank you so much. And apologies, sincere apologies for the, terminology, but the PKK problem, let's say PKK problem, is generally referred to as Kurdish problem in Turkey, and this was an honest mistake. So we will be more careful with the terminology we use in the future. And regarding, so I tried to explain this in the methodology slide that I use. Our scope of inquiry is limited to, acts of torture, ill treatment, as well as extrajudicial killings. One case study, Gökhan Açıkoğlu, a teacher who was tortured and basically extrajudicial killed by Turkish security officers, deals with that issue. So impunity, as you might agree with me, is a very big problem, multi-sided, multi-dimensional, and it's also an overarching problem because other reports of the Turkey Tribunal deal with specific human rights violations, right? So the impunity here is the overarching problem encompassing all specific human rights. But for the purpose of the report, we had to limit. Otherwise, we would ended up with like 1,000 pages of report, right? So this was kind of a choice of the authors to limit the analysis to acts of torture and ill treatment. But otherwise, you're right. So impunity is relevant for especially serious crimes, and these are not just torture and extrajudicial crimes, but also enforced disappearances. There is also impunity for enforced disappearances in Turkey. Just our reporter, Johan, talked about this report. yeah, impunity is also relevant for other serious human rights violations as well. Thank you.
Thank you. Second question. For the purposes of impunity, the question that we have to answer regarding impunity, what is more important in your view, international human rights law or indeed the domestic law of Turkey? For example, if we focus on abductions, for example, well, let's take torture first. I think it is very unlikely that the domestic law of any country would say torture is allowed when it's really necessary or when it's reasonably necessary or whatever the term may be. Therefore, impunity will start with the domestic law, which will necessarily make torture a criminal offense, and then of course international. But let's take abductions, for example. International law will have rules regarding disappearances. Domestic law will deal with what you mentioned here. When somebody is arrested, how long does it take before you're brought to a court? The emergency regulations made it which were in place for 6 months. They said 30 days or something?
30 days.
Yeah, and then it was amended to be 7 days. Now, most of our example cases deal with months or years, which would fall outside all of that. But if there is a disappearance for 10 days, does one look at international law firstly, or the general Turkish law regarding things like kidnapping, or the specific emergency regulation at the time when this thing happened? Thank you.
Okay. I mean, I understood your question as kind of a jurisdictional question or kind of a temporal. Maybe you might want to clarify on that because yeah, I mean, the prosecution of any acts of torture or abduction depends on, when this alleged act took place and what is the applicable legal framework. So your question was more of a jurisdictional question?
No, it's not really a jurisdiction. Let's focus on one example. Let somebody disappeared for 15 days. Do we start with the international human rights law on disappearances, or do we start with the general Turkish provisions about arrest and detention? And do we have to analyze the emergency regulations as to whether at that point of time the period was 7 days or 30 days? Or is the overall, of course, it is also possible that these emergency regulations itself could be unconstitutional and in violation of international law. But where would you focus? Where would you focus? On the narrow, immediate thing that applies? The policeman was supposed to follow, this and that rule in domestic Turkish law, or the bigger international law picture?
I mean, as long as impunity concerned, or these massive violations, including torture or abductions, it's always wise to start with the domestic law. How domestic law functions, and there are general laws. You can take a look at the Constitution or other specific legislation, but these provide some sort of a general protection. So if there is an emergency, state of emergency applicable, there is always some sort of a lex specialis which takes precedence over general legislations and regulations. So it might be wise to take a look at these specific legislations and then general legislations. So if you're done with the domestic, analyzing domestic legal fora, then you have to take a look at the legal standards, because domestic legal frameworks are much more comprehensive than international human rights instruments, right? I mean, international human rights instruments.
Yeah, I'm not going to ask another question, but let me just explain why I asked the question. Because we are looking at the international human rights picture. But if a country, its officers, its police, its courts do not even follow the simplest of its own domestic law, and break that, then it is not only a matter of violating international law, then it is a country without the rule of law.
Exactly.
Then it is a lawless society. Thank you.
Just to quickly add something, that will be our conclusion too. So
It's not my conclusion.
or the reports, the report's author's conclusion, because the Turkish domestic legal framework, to a certain extent, has strong compatibility with international human rights standards. But if there is no political will, if there is no rule of law, so that means all these legal frameworks are vague and abstract, so they are not put into practice, basically. That is the case in Turkey right now.
Okay, thank you very much, Judge Bayens.
Thank you. I have just one question. Among the factors that contribute or enable impunity, the last one that you highlight is what you call the judiciary, the complicit judiciary. And among that, or within that, you point out some of the challenges that the judiciary faces, including the forced, the dismissals and pressure and the chilling effect. In your research, did you come across a direct, or can you identify a direct correlation with attempts to prosecute cases of torture by state officials with these type of consequences for the prosecutors and judges that are trying to do the right thing? So dismissals or forced removals or transfers or any other of that kind of pressure?
Well, I think we should distinguish between prosecutors and judges. They have different judicial practices because prosecutors in Turkey basically work for the government, and judiciary, is comprised of judges, high courts. So the correlation is that since maybe over the past decade, Turkish government is trying to put enhanced pressure and enhanced grip over the Turkish judiciary, and of course these are not easy to prove on paper. We cannot take a look at the statistics, but these statistics are not enough to see the bigger picture. So there is of course correlation, and we try to provide an annex in the report. Of course, this goes beyond our temporal focus. If you take a look at the Annex 1, and this is a table that explains the judiciary's practice with regard to serious human rights violations that took place in the 1990s. So these are the cases of extrajudicial killings and enforced disappearances. So this is the annex to the report. So I will just read. So this NGO called Hafıza Merkezi in Turkey gathered data on judicial proceedings of over 300 individuals. Now, only 81 of them have proceeded to become criminal cases, and in over 200 cases, the prosecutor decided not to pursue investigation, not to file charges. 15 cases out of over 360 cases have managed to reach the trial stages, and only 2 perpetrators have been held accountable. The rest 13 concluded with acquittal or dismissal decisions due to statute of limitations. So, I mean, we can only take a look at the statistics, whether there is a correlation, right? And which is, I mean, eventually we were not planning to include the approach of Turkish judiciary in the report because, as you said, it's hard to prove this correlation. But as far as the impunity problem is concerned in Turkey, they are part of the picture, right? Because Ercan Korkut, as I said during my presentation, will testify later today. And his brother was shot. There was a footage of the incident. Who shot him is clear, but the Turkish court decided to acquit the police officer. On what ground doesn't make any sense. So I'm just as puzzled as Justice Wethusen. So they don't even care about the legal framework. So they have responsibility, the judiciary has a responsibility. They should act as a remedy. But sometimes there has been these decisions which, you know, puzzles, you know, the international community as well as the domestic community. That would be the...
Okay, thank you very much. Thank you for your excellent report.